Good evening, friends. Let us dive into another case law which has been newly added into the syllabus of Advocate on Record Examination. The case law is TEJ PRAKASH PATHAK versus Rajasthan High Court. This was heard by 5 judges bench, including Honorable Chief Justice D.Y. Chandrachud, Justice Rishikesh Rai, Justice P.S. Narasimha, Justice Pankaj Mittal, and Justice Manoj Mishra. The question involved in this case is whether the rule of the game governing a recruitment process can be changed during the recruitment after the recruitment process has commenced. I am repeating the question whether the rule of the game governing a recruitment process can be changed after the recruitment process has commenced. This is the question to be decided by this honorable bench. Friends, let us dive into factual background of the case. By its notification dated 17th September 2009, the Honorable Rajasthan High Court invited applications for the posts of translators. The relevant rules specified the qualifications as well as the method of recruitment to the posts, which included an examination consisting of written test followed by an interview. After the examination, Honorable Chief Justice of the High Court added a minimum percentage of 70% in the examination for filling up the posts in question. Some unsuccessful candidates filed a writ petition before the High Court contending that the Chief Justice's decision amounted to changing the rules of the game after the game is played. After the dismissal of the petition by the High Court, a special leave petition was filed before a three-judge bench of the Supreme Court, doubting the correctness of the court's previous decision in K. Manjushri versus State of Andhra Pradesh, 2008 INSC 195, shortly K. Manjushri case. The case was referred to a constitutional bench of 5 judges for an authoritative pronouncement on the question. Honorable decision, Supreme Court gave its decision. The constitutional bench, 5 judges bench of the Honorable Supreme Court, unanimously held that the existing rules governing eligibility criteria cannot be changed once recruitment begins, unless the existing rules permit it. However, recruitment bodies can devise appropriate procedures or methods of selection during the recruitment process as long as they are transparent, non-discriminatory, and rational. The court upheld the decision in K. Manjushri. The judgment of the court was authored by Justice Mishra. Now, let us dive into reasons for the decision. Rule of the game should not be changed during the game. The Honorable Supreme Court held that the process of recruitment begins with the issuance of advertisement and ends with the filling up of notified vacancy. The court held that doctrine which stops the change of rules midway through the recruitment process is founded on the rule against arbitrariness in Article 14 and 16 and the doctrine of legitimate expectations. The court reasoned that these provisions require the state to act in a fair, transparent, and non-arbitrary manner. Candidates have a legitimate expectation that selection will be based on known criteria and public authority should act predictably unless there is a good reason not to do so. procedure prescribed in the existing rules not to be violated. Honorable Supreme Court ruled that the principle that the rules of the game could not be changed midway did not apply with as much strictness to the procedure for selection as it did to the fixing of the eligibility criteria. The court held that recruiting bodies could devise appropriate procedure to conclude the recruitment process, provided the procedures did not violate existing rules and were non-discriminatory, non-arbitrary, and had a rational nexus to the object sought to be achieved. The Honorable Supreme Court reasoned that where the relevant rules were silent on the procedure of selection, the recruiting body could fill in the gaps through administrative instructions, provided they did not violate the provisions of the rules, the statutes, or the constitution. But where the rules covered the field, the recruiting body had to abide by them. K. Manjushri is not at variation with earlier precedents. Honorable Supreme Court observed that in K. Manjushri, the existing rules had not specified the procedure of selection. Thus, the concerned authority came up with an aggregate qualifying percentage for the written examination and interview. The rule was then changed following the completion of the interview process, adding a minimum qualifying percentage for the interview in itself. In these circumstances, the Supreme Court held that the change was illegal as the considerations of the examiners in evaluating the candidate would have been different had they known that there was a minimum percentage for the interview in addition to the written examination. Honorable Supreme Court addressed the contention that the decision in K. Manjushri contradicted State of Haryana versus Subhash Chandra Marwaha. In Marwaha, following the preparation of selection list, the recruiting body fixed a percentage for the appointment from amongst the names in the list. This was upheld with the Supreme Court ruling that such an act came under the purview of administrative policy. In the present case, the court held that Marwaha dealt with the right to be appointed from the select list, whereas K. Manjushri dealt with the right to be placed in the selection list. Therefore, it ruled that K. Manjushri could not be at variation with Marwaha, as both the decisions dealt with separate questions. Appointment may be denied even after placement in selection list. The Supreme Court held that a candidate placed in the select list has no indefeasible right to be appointed to the post in question, even if vacancies were available. It reasoned that state was under no legal duty to fill all the vacancies if there existed good faith reason not to do so. So, friends, this was the case law which has been newly added in the advocate on record examination. So, go through it and God bless you have a good marks in the examination.